allegation is to authorize a fair ballot title.
Well, you'll note.
I'm just wondering if it's fair and clear to say it's permanent sales tax when it can be.
Seems obvious that I'm not going to win that argument, which also wasn't the argument that we put up. The argument that we put up is that this violates the single issue point. That's why we didn't put that in there, because we kind of thought this might happen. Look, it's not necessary to put in the thing about the jail utility fee because it's going to sunset anyway, and the city council could put it back on the next day. So any vote that anybody has, where they think that they're influencing that weather pattern, it's false. Second thing is, they said that they've run out of room to put any additional words, permanent or any other thing, temporary. Well, that would give them the room. They could put in all kinds of things. See, in this case, they're saying, do you like kittens? Do you like sunshine? Oh, and also here's the tax. Now, we don't need to, let's just lay it out in front of the public. Put this first. Put something else second if you like. But let's just be honest with people and tell them. May I share one additional detail, sir, or would you like me to wait till later?
Well, you get a chance to rebut what the other side says.
This won't be a rebuttal of what they have to say, so I want to be sure it falls within
it relates to the ballot title.
When I did the best that I could to turn in these papers and trying to follow the procedure, I took our pleading here to the city council chambers and asked, to whom should I give this? And I was told by Mark Bartholomew, I cannot give you legal advice. I just wanted to know who to turn it into, sir. That's all that I wanted to know. I asked him, can you tell me, please, who wrote this? I thought that might be a clue. He said, I don't know. I don't know. That, to me, sir, is emblematic of this entire process. If they just be straight with us, then we can decide what we actually want to do. I'm just asking that the public gets the straight information from their city government. That's all.
Thank you, Mr. Mayor.
Thank you, sir.
And Mr. Bartholomew,
thank you, Your Honor. I'm Mark Bartholomew, City Attorney for Grants Pass. First off, I want to respond to something Mr. Matthews just said. He just lied to the court. He never asked me who wrote this. If he asked me who wrote it, I would have told him. There's no reason I wouldn't tell him that. So just to make a record, he lied. I appreciate the fact that you've read the memos we submitted in both cases. I think they're comprehensive. The case law is quite clear. I'll respond briefly to the allegation that we violate the single subject rule. Of course, the Constitution says an initiative shall embrace one subject only and matters properly connected therewith. In this case, we've got really three things going on with the ballot measure. We've got a sales tax that would be implemented. We have the property tax levy that would be removed, and the jail utility fee would be taken away. So the case law on this to discern whether or not it embraces only one subject is whether or not there's a, quote, unifying principle logically connecting all provisions. If so, then it covers a single subject and passes constitutional muster. So in this case, the unifying principle is public safety funding, and the matters properly connected therewith are the sales tax and the removal of the jail utility fee and the property tax levy. One of the arguments that I think Mr. Graham made in his brief, or perhaps Mr. Matthews, was that someone may want to, and Mr. Matthews just made an oral argument, someone may want to vote for one part of this, but not another. So the wealthy older gentleman who just wants all the taxes in the world, he's somehow deprived of the possibility to still be subject to the property tax levy, the jail utility fee, and the sales tax because the operation of the initiative is to remove the fee and the property tax in lieu of the sales tax. The Supreme Court of Appeals addressed that very issue. It's directly on point. Supreme Court, actually, Oregon Education Association versus Phillips, and the court said that you may have an issue like that may present that voter with a difficult choice, but if the limitation on elections were not found in the measure, another voter might well face the difficult choice of desiring to vote for most of the measure, but not wanting to do so unless it also contains such a limitation. And I think that example is far more germane to the voters in in Grants Pass than the example Mr. Matthews gave. I think, certainly people may be interested in voting for a sales tax to supplant the other taxes. Very few people would want all of those taxes and or fees. And if we were to do it the way they suggest, it would be an a la carte option. So you have opposite spectrums. You may have someone who votes to retain the utility fee and votes to retain the property tax levy, and then the voters also vote to implement the sales tax. Well, then you've got too much money, and that's not fair to voters. However, they may all get rejected, in which case we're in a worse public safety funding situation than we have right now. And that's not good for anybody either. So not only would that violate law to rule in that direction, it would also be terrible public policy. The example that Mr. Matthews gave regarding kittens and sunshine was also directly considered by the Supreme Court in the case of McIntyre versus Forbes. And that's, I think, the only case we found where something was invalidated under the single subject rule. And that was because that proposed law covered such a wide range of topics, such as state funding for light rail, expanding the availability of card-locked gas stations, promoting regional problem-solving and land use matters, regulation of confined animal feeding, preemption of local pesticide regulation, adoption of new timber harvest rules, immunity to shooting ranges for noise pollution, and protection of salmon. So that's your kittens and sunshine case. And so I think the court actually refers to that as log rolling. So that's the public policy behind the single subject rule. When you have a proposed measure that pits two drastically unrelated items where a voter ordinarily wouldn't be inclined to vote for one, but for the fact they have to vote for the other aspect of it, which they are in favor of, and to get the whole thing through. So it's kind of shoehorning or bootstrapping something else in that's completely unrelated. That is not what we have here. So moving on to Mr. Graham's arguments, generally the case law on the specific ballot language, court says, this is again Supreme Court Burbridge versus Paulus, we are not concerned with whether petitioners' proposed titles may be better or even whether we could devise a better one ourselves. They just need to pass, a statutory muster, and they do. For instance, the caption. And again, I think this needs to be viewed through the prism or viewed from the understanding that we're constrained by word limits. I've worked on several ballot titles before, and there have been times when my colleagues and I have just kind of pored over the language, trying to come up with synonyms to replace longer phrases so we can stay under the word limit. I mean, you're really held in check. It's a challenge to come up with the wording to stay under the word limit for these. So in this case, the caption has to be 10 words and reasonably identify the subject nature of the measure. Well, it does that. The question, not more than 20 words, plainly phrasing the chief purpose. We believe that it does. They're arguing that the wording should be reorganized. They say that they're suggesting that the sales tax should be the first item, the first thing mentioned in the question. However, my response to that is, one, I think that violates Burbridge. That's just their subjective editorial position on this. And two, I'm sorry, we violate Burbridge to change it.
Let me just ask you for the argument. Couldn't the city say, shall the city implement a 2% sales tax and eliminate a 1.79 per dollar property tax levy, eliminate the jail and utility fee? Couldn't you do that just easily?
We could. However, the law is pretty clear where it's, the law in that case is whether it plainly phrases the chief purpose. And I think the chief purpose of this is just as much the elimination of the property tax levy and the utility fee as it is the implementation of the sales tax. I think that, the opponents are focusing all the attention on the sales tax. That's not really the point here. The point is criminal justice funding. And those are the three elements to it. And so they're focusing on the most undesirable one, or the one that gets the headlines, and that's sales tax. Sales tax is no more important to this than the elimination of the levy and the utility fee. They also say it doesn't use the word permanent. I think you touched on that, Your Honor. Nothing's permanent. The city can revoke the levy or the utility fee or the sales tax, for that matter, at any time. The city council, as a matter of fact, could have implemented this the sales tax without other people. However, I think it would be politically difficult to do so. They say it also, I believe that it would mislead voters if we were to say that the sales tax is permanent. Because again, it could be revoked. So it's misleading to say it's permanent. They also say that we're not mentioning that the utility fee and the levy will expire. Well, I think it would be perhaps misleading to say they're going to expire. Because if you look at the history of property tax levies in Grants Pass, the city of Grants Pass has relied on that funding since at least the 1980s.
What do you think of Mr. Graham's point that the average voter doesn't understand that?
I think I'd be offended if I were the average voter.
But you're not.
So, yeah, with regard to the utility fee, the original implementation of that gave a sunset date to that. That utility fee was re-implemented in response to the latest failed criminal justice levy, the countywide justice levy. So the city council re-implemented the jail utility fee in response to that. So most of the arguments I heard from Mr. Graham, they're not legal arguments. Talks about the indoctrination of voters, the notion of permanency. It cuts both ways. Nothing here is really permanent. It'd be misleading to describe the sales tax as permanent. And touching on what you just said, his argument assumes that voters are incapable of reading the entire ballot question. The question is 20 words long. It mentions sales tax on the next line, and actually the same line as the utility fee. And you read 4 or 5 more words into it, you see sales tax. So it's not like it's hidden. It complies with the word limitation. I think that's why, by statute, these are limited to 20 words. You can't bury anything or hide anything in 20 words. So in closing, we were aware of the scrutiny that would ensue. I mean, sales tax are unique in Oregon. Voters in Grants Pass and Joseph County are sensitive to taxes and fees, and they should be. And as staff and the council, we want to prepare something that's correct and legal and leave it for the voters to decide, and I think that's what we've done here. Thank you.
Thank you, Mr. Bartholomew. And Mr. Graham, rebuttal?
Your Honor, the city has this problem about this initiative in that they have to sell to the voters. They can't sell to the voters unless they take away some of the taxes in order to impose a new tax. And that's what they're doing here. They frame this question as a marketing tool. Hey, look, we're getting rid of these taxes and the levy, and we're going to replace it with this tax over here. In reality, they're passing a sales tax. I think that the court took my comments and addressed them to them and say it should be worded as the court posed the question to Mr. Bartholomew.
Let me just talk to you about that, because I was looking at that, but I noticed the caption starts out with mention sales tax. The summary starts out with mention sales tax. And so the fact that the question doesn't, the question starts out mentioning the levy and the utility fee. I'm not sure that's significant. It was just kind of corrected if there's any misapprehension by the caption and the summary.
Well, should they be consistent? That's the point. They should be consistent. You're adopting a sales tax. That's what this is all about. The question is, is the city voters going to adopt the sales tax? That's the question. Be consistent. That's what the petitioners are asking. Don't hide the ball here. Thank you.
Thank you. Mr. Matthews, rebuttal.
Sometimes in the law, you go back to the intention of the original framers and looking very carefully over hours of the city council itself talking about this and asking questions about this. there are at least 2, maybe 3 city councilors that said, don't you think that we ought to revise the order of this? Why aren't we putting the fact that this is a sales tax, why don't we put that first? Wouldn't that be more honest to the people? Well, that's not the way it's framed. The way it's framed is, as opposition here said, well, it's all about keeping people safe. I don't have the exact quote. It's all about keeping people safe. Well,
Mr. Matthews, you got to agree with me that the caption starts out by saying sales tax for city public safety, and the summary starts out by saying this sales tax eliminates.
I have to agree with you, yes, sir. It's your court. I do have to agree with you, yes, sir.
Okay. And the fact that the question starts out by the elimination of the fee and the levy,
right,
and then goes to the sales tax, how significant is that?
I think the significance behind that, as my colleague here said, is that they're just trying to be sure that we get the point that they want us to get. That this thing is really about, as Mr. Bartholomew said, it's really about, it's not about a sales tax. It's equally about eliminating things that are going to make you safer. No, they're not. This is about trying to convince you that if you say no to something you'd like to say yes to, or you say no to something where you'd like to say yes to, or no to everything, then, well, don't worry about it. It's all going to be okay. If it was true that this was about keeping us safer, then those 2 other things wouldn't be on here at all, because that's not going to keep us safer. That's going to actually decrease the money. And the city councilors said, well, this isn't going to create enough money if we do this, or we do this, or we do this. Maybe we need to do all of them. And a number of the people who came up, and we looked at all their comments too, that were trying to advise the city council, said, why are you getting rid of something? I don't want you to get rid of that. Now, how are they supposed to vote? I would find it difficult if I was in their shoes to say yes or no to this, because the things are combined. And again, the whole idea that something that's going to sunset anyway is on here is just a blatant attempt to try to convince you that you have control over things when you don't have control. The last point that I would make, sir, is that it's been stated here several times that all these things could be reversed or set up again by the city council. Do you think the voters have any idea? This is not the way it's being sold to the voters. By the way, if you vote for this, it probably doesn't mean anything, because we can outrun you anytime we want to. No, it's making them think that they have some kind of control when they have no control. Let's just be honest with people. What's the difficulty with saying it straight out? In all of the permutations of this, this is what's going to happen. And if you decide to say to them, look...
Saying it straight out by saying this is a permanent sales tax, it's never ever going to go away.
No, I'm not going to argue that, sir.
When it comes to fee, it is going to go away.
I can't argue that with you, sir. You've made it clear what you think about it. Okay.
Just asking.
Sir, since you've made your feeling clear about that, I'm not going to argue that. What I'd like to say is that if you do decide to tell them, fellas, go back, let's just make sure that everybody understands the real issue here. The real issue is not asking to take something down that's going to go down by itself. The real issue may end up being that you can bring it back anytime you wish with a snap of your fingers. That may be a real issue. I'm surprised that was brought up here today. No, you could say to them, look, this isn't going to cause you any headaches. Just reword part of this. And as far as somebody saying, well, we knew that there would be lots of scrutiny. Well, that's not what was said in public. What was said in public is, and to us, nobody's challenging this. Well, yes, we are. And we just like a little more clarity for the voters. And if we're going a little overboard for clarity for the voters, well, it's just because I don't think, as has also been stated, that the voters are going to be confused if extra words are written in, or maybe it's changed in this order. I don't think that's going to cause them any problem. It's not going to pass anyway. But you could say, listen, fellas, let's just play fair with everybody. I hope that you do, Your Honor. Thank you.
Just one final point. I mentioned the Burbridge case. Again, all they're touching on is they think it should be reworded. To me, the 3 prongs to this are all inextricably linked. The court says we're not concerned with whether petitioners' proposed titles may be better, or even whether we can devise a better one ourselves. It's simply whether it plainly phrases the chief purpose, and usually it does. Thank you.
Well, pursuant to ORS 25-250.296, the court is directed to review the title and measure to be initiated or hear arguments, if any, and certify to the city elections officer a title for measure which meets the requirements of ORS 250.35. It indicates the review by the court shall be first and final review and shall be conducted expeditiously, and that's what I'm going to attempt to do. As I mentioned, I tried to get prepared for this over the weekend by reading the cases. Responding to the petitioner's objections, the first one is the single subject objection that both Mr. Matthews and Mr. Graham put forth. And I did read the cases, and I agree with Mr. Bartholomew that there has only been one case in the appellate history in Oregon that has invalidated ballot title based on the single subject, and that was the McIntyre case. And Mr. Bartholomew recited the facts of that case were really 6 or 7 very different, diverse topics were attempted to be put to the voters by referendum, and the court said that violates the single subject. There are other cases that are a lot more, have a lot bigger variety in the cases for the subjects than this one that were found not to be invalid based on the single subject. One is Fugate, and in Fugate, the referral was, the first was a crime victim's right measure, the second was something to do with evidence in criminal trials, the third was release criteria of criminal defendants, the fourth was criminal sentencing and restitution, the fifth was the law concerning jury makeup. So pretty diverse topics. And yet, the court found that there was a unifying principle, and therefore the single subject constitutional prohibition was not violated. I don't find that to be the case here. I think that the unifying principle is an attempt by the city to fund public safety and criminal justice services, and that's what the caption says. So that challenge will be denied. And as Mr. Matthews said, he knows my feelings on the inclusion of the word permanent in the ballot title, which I think would be very misleading and false to the voters. Permanent, according to my dictionary definition, maybe I can even find that, is existing perpetually, everlasting, and tell the voters that if they enact a sales tax, it's going to be there until the world goes away, I think would be false, and so I'm not going to approve that change. Mentioning the fact that the levy is set to expire in a couple of years, and the jail fee in, I think, 2 years. I'm not going to add that. I disagree with Mr. Graham. I think the voters are pretty sophisticated, especially when it comes to money measures. I think that an average voter does know what a levy means, does know that it has to be reauthorized by the voters. I'm not going to order that language be included. Both parties have asked that the caption be, the fact that the question does not start out by mentioning the enactment of the sales tax, I think is cured by the fact that the caption does and the summary does. And as the case law tells us, it doesn't have to be perfect. It has to be accurate and fair, and I think that it is accurate and fair in light of the fact that the caption starts out by saying the sales tax for city public safety and criminal justice services. That's the headline. I think that's the first thing people read, and once they've read that, they take everything else in that context. And so when they go on in the question to say, shall the city eliminate a $1.79 property tax levy and eliminate the jail utility fee and implement a 2% sales tax, I think the voters clearly would understand that that is in the context of enacting the sales tax, especially in light of the fact that the summary starts out the same way. This sales tax eliminates the local option property tax, so I'm not going to order that to change. I think the only other thing, Mr. Graham in his written pleading objected to the fact the levy on the average household would be reduced by $277, which I think in vacuum would be well founded, because we really don't know what an average household is. But I think that's cured by the explanatory statement. In the explanatory statement, there is, under tax impacts, there's the information beginning in fiscal year 2017, the period starting July 1st, 2016, the city's local option levy of $1.79 per thousand, the assessed value will be eliminated for a single-family home in Grants Pass with an average taxable assessed value of $155,000. And so I think that defines what an average taxable household or average household is. If the measure is approved, the property taxes for the average city home would be reduced by approximately $277 per year. So I think that's here. So I'm going to deny the challenges to the ballot. I will approve the ballot. Mr. Bartholomew, would you drop a consistent order?